appears for the Mombasa County Returning Officer? Let's have some settlement around here. Kindly, let's have some settlement around here.
Chairman, members of the committee. My name is Edwin McKenna. I appear together with Mr. Ndaiga for the returning officer.
Anybody else?
I appear for the governor.
And is which party in that? Let's be clear. Is the governor a party to these proceedings? The complainant?
In 136, yes, he is as an interested party.
So that's Dr. Kaminwa.
My Lord, Your Honor, we are together with our senior, Mr. Kamina. My name is Wilfred Jam, alongside Mr. Bichile.
Alongside Mr.
Bichile.
It's Bichile. M-B-I-C-H.
Bichile.
Yes, Bichile.
And Mr. and Senior Dakundi. Advocate, General of the General Council.
You don't know your people?
Your Honor, unfortunately, we are many, we are a big team, so we keep on coming. Cherriot is also here.
Yes, we are going to deal with one for introductions. Okay. Yes?
Honourable members of the committee, my name is Kagushia. I represent EACC. I have an application to...
No, let's get in introductions first. Kagushia. We will get there.
For EACC.
Yes.
I'm not yet a party. That is why I'm mentioning I have an application before you, honourable members, to join and to respond to...
Are you a party in any of them?
124.
In 124. We'll take you in 124.
Most obliged.
Any other party who is appearing? Okay, so I take it that these two consolidated matters are 136 and 124, isn't it? So we'll use 136 as the lead file, okay?
Your Honor, Honorable Chair, 136 and 124 were filed by the same party.
Yes.
And we had indicated that the file that we will be proceeding with will be 136 for the reasons that the opening of the two files was not our creation, the creation of the commission.
So 124 stands withdrawn.
Yes, because it's the same, the documents in them are the similar.
Okay, so DRC number 124 of 2022 marked as withdrawn with no orders as to costs.
Honorable Chair, another thing, unless, and we have not been served, unless the Ethics and Anti-Corruption is seeking to be enjoined into this complaint, they are not parties.
That's a fact.
Yes, so we are here to be served with.
That's a fact. Let's proceed with the parties who are there. They said there were only parties in EACC 124.
With the permission of the members of the committee.
Yeah, quickly, so that you know we have a lot of matters. We have 10 matters, so I need us to go with speed. Kindly, Mr. Kagushia.
Generally, we're responding to expenditure to the candidates, government. So whatever affidavits and application to join was being filed in respect of the matter that we were aware of, which is 124. And the position until 5 minutes ago was fine.
In respect to 124 has been withdrawn. It's no longer an issue. It's been withdrawn, and we've granted the order of withdrawal. Let's proceed, please. Yes, it has shifted. Shift with it. It's gone. 124 is gone. I would have heard you objecting. I didn't hear you objecting. Let's proceed. Let us proceed. Complainant, proceed with your case.
Honorable Chair, I'll allow my colleague to...
Sorry? We have two people talking. You have the floor. You said you're Mr.?
Mr. Wanyanga for the...
Mr. Wanyanga.
Yes.
How many minutes do you need to prosecute your case?
You know, as between the advocates representing the complainant...
Only one will speak. How many minutes do you require?
You know, we...
Quickly, or I call the next matter.
We'll take 15 minutes and we'll share the time between us.
15 minutes, you share the time.
Yes, but yesterday you had indicated we'd be able to have 30 minutes.
Yes, 15, you share the time. IEBC, how much do you require? Mr. Kagushia, if I were you, I'd be running to make an application to join 136. You're standing there.
Chair, in fact, I think my makeup is because it's exactly the same thing, it's just the number.
Then go change the number and come.
Withdraw the record.
Run,
And even edit
run,
it myself,
run,
it's
run,
exactly
run,
the
run.
same.
Give him back the document.
I just need to change the numbers.
Yeah. That does not mean we've allowed it, eh?
No,
Yeah.
I'm not taking any
Give him,
decisions.
Commissioner, give him that document. Run. It's in your best interest to do so. Yeah.
Honorable Chair, I'm consulting with my colleagues and we are proposing to have 30 minutes.
No, you don't have 30 minutes. You have got 20 files. You have got equality of right between a person who's running for governor and a person who's running for MCA. We will not give you... I will... 15, 20. 20 minutes at the most, and we will time. IEBC, how much time do you require?
Most an equal amount of time.
20 minutes. Who else is in these proceedings? 120.
Your Honor, we are an interested party.
You already joined as an interested party, or you're applying?
We had enjoyed them at
Yes, and we will only discuss it on points of law.
In points of law. So 10 minutes?
Yes, 10 minutes.
10 minutes. So 15 minutes, 20 minutes, that is 30, 35 plus 10. So a maximum of 40 minutes. May I start by saying this, gentlemen? We all understand the public interest that is in this particular matter. I want us to conduct these proceedings with dignity, without shouting. Stick to your issue. From the decisions that we've made earlier, you have noticed that this committee of IEBC has only one role: to oversee, to have an oversight role over what its returning officers have done. Others uphold the decisions of the returning officers. You have others vary the decisions of the returning officers. Affirm the decisions of the returning officers. This is not a political contest here. Tell us one thing. What wrong did the returning officer do? If it is the party, what does it want? In the event the decision is revoked, is upheld, let's just stick to that. Okay? You are all my colleagues, you know that. I don't wish to cut any one of you. There's a new in town. I don't wish to cut anybody. Let us do this in a sober manner, in a decent manner, and we will do justice as we would do for anybody in it. Okay? Good. With those matters, Mr. Wanyanga, isn't it?
Yes.
Okay. Let us. Yes, please.
From what I understand, the issues in the wiper party matter and the matter by Honorable Michael Sonko is basically Article 75. We hear them.
Mr. Mukeli, let us hear their case. You okay. So let us go in an organized manner. Mr. Wanyanga, tell us what your issues are in 136.
Yeah, pursuant to
Let our assisting counsel just summarize for our case as we have understood it. That's the practice we've adopted here.
In summary of the case recorded,
Sauti.
the Wiper Democratic against the Commission's refusal to hear or nominate the failure to present an original degree certificate or certified copy and breach of Article 75 of the Constitution. The complainant maintains that he has a pending case of the Supreme Court against the impeachment motion. That is petition number 11 of 2022 at the Supreme Court, and Nairobi petition E090 of 2022, consolidated with E158, E221, E230, E249, and a border petition number E010 of 2022, and Mombasa petition E017 and V019 of 2022. The relief sought are as follows: that the interested party be cleared on the strength of papers submitted to the Commission. 2, declaration that the interested party has a live appeal at the Supreme Court, being petition number 11 of 020. 3, that the interested party be cleared to contest for the position of Mombasa County Governor in the 9th August 22 election.
Okay, thank you. Mr. Anyanga, your time begins now.
You know, I'll allow my colleague to start, and then we split the time between ourselves. Yes.
Chairman, thank you so much. Indeed, that contains the summary of our case. I'll start by saying that everybody in this country, yourselves, all Kenyans, it doesn't matter their tribe, it doesn't matter whether they are short or tall, everybody is entitled to justice before this court, before this land, before tribunals. It doesn't matter even if somebody has committed sins in the past. Everybody is entitled to fair hearing before a body that is able to be independent and be seen to be independent and above board. That concept of justice is important. You cannot separate the concept. Even a 2-year-old can know if you're treating their 4-year-old sibling unfairly, and they would cry out in protest. And what are the rights we're talking about? What we are referring to is what is called natural justice. The right to be informed through a decision that is reasonable, through a decision that meets logic of the reason why a certain right by an administrative individual or body has been denied. Natural justice also dictates that everybody is given an opportunity to be heard before being condemned. You cannot be heard without being, you cannot be condemned without being heard. This concept of natural justice also dictates that you cannot sit as a judge in your own cause. What does that mean? It means that any person, any individual that sits to hear any case in this country against anybody, because it's a right we have to protect for everybody, because you never know tomorrow. that bench, that tribunal, that one must not have a personal interest in the outcome. So that you're sitting, and yet you cannot separate yourself from the decision that is going to be made, or you have personal interest or financial interest or any other manner you are involved in the outcome of the decision in a way that will be biased or prejudice the individual appearing before you. And what are we saying? The law allows the returning officer, and here we're talking about the Mombasa County returning officer, to abide by certain principles that are secured under Article 10(2) of the Constitution in executing her mandate, so that she has to do the right thing, follow the law, hear a person, and ensure good governance. Article 47, administrative action has to be present. If it is not present, any action, any outcome has to be taken and interpreted in a manner that supports the aggrieved individual. So these natural justice principles I've talked about, the right to be heard, the right not to be a judge, to be judged, to sit as a judge in your own cause, the right to get a decision that is reasoned, have been codified in our Constitution. When you look at Article 20, and I'd like to take you there, because Article 20 is of fundamental importance to the matter before you. Because the actions with which we are appealing against the decisions are the actions of the returning officer as compounded by statements by the chairman of the IEBC, Mr. Wafula Chebukati, in his press statement of 4th of June 2022, in which statement he clearly condemned Honorable Sonko, knowing well that there is an IEBC tribunal to be established in which any grievance is supposed to be heard before. When you look at that statement, and you'll have opportunity to be taken through, you'll find that he has made, he has addressed certain matters before court that Mr. Sonko and Wiper as a party have not had an opportunity to respond to. So Wiper had an opportunity and still has an opportunity, when you look at our authorities, which you look at, to field a candidate of choice.
An opportunity or a right?
A right and opportunity. And I referred to Article 20 of the Constitution. A right and opportunity. So when you look at Article 20 and you look at the press statement by Chebukati, as I'm summarizing, you'll find that Honorable Chebukati, as a chairman and national returning officer, has overlooked all those natural justice principles together with the returning officer. They have overlooked rights that are secured because he attempted to interpret certain articles of the law without reference to the law itself or even judgment law or any rules at all. He made an arbitrary decision to the detriment of Wiper Democratic Party. So that article states that any interpretation, as was done by Chebukati, if I can just go. So the Bill of Rights.
Okay, let me ask you.
Yes.
Who refused to clear the interested party?
So,
answer me, just submit.
The person that refused to clear the interested party, and I'm glad to inform you that there will be a clip and you'll see the reasons in the clip.
Who cleared?
Is the returning officer, but the returning officer, as she was leaving the station, said that her hands were tied because she was waiting for feedback from the legal department and IEBC, and that the chairman had pronounced himself with respect to that specific clearance.
Do we have jurisdiction over the chairman?
So this is our position. So first, to answer your question, officer, jurisdiction over the chairman and his. It's very an independent bench or any with respect to this matter. All heads of the bench like the sword of independent, and we have faith in that, irrespective. Thank you.
Honorable Chair, I will take a few minutes before I allow my colleague to summarize, two colleagues to be able to summarize. We approached you after invoking our rights to object before the returning officer, pursuant to our letter dated 7th, the letter by Honorable Shakila that was forwarded to the returning officer Mombasa, indicating our displeasure or our disagreement with her decision to disqualify our nominee on two faults: failure to present original degree certificate and or certified copies of the same, and of most importantly, on the issue of breach of Article 75. Honorable Chair, I will not belabor on the issue of the documents, because that will be addressed by the party who is an interested party in this suit. I will be able to address your minds to breach of Article 75 of the Constitution. And Honorable Chair, a Constitution as it is cannot be read in isolation of other provisions of the Constitution, such that qualification of our nominee as enshrined under Article 180, as read together with Article 193, encompasses even the provisions of Article 75. I will demonstrate this in this way. Looking at Article 193, sub-article 2, or 193 that gives qualification, sub-article 2 giving instances when somebody will be disqualified, and more specifically looking at paragraph number G, 2G of 193, provides that one will be disqualified if he has been found in accordance with any law to have misused or abused a state office or public office, or to have contravened Chapter 6. Honorable Chair, the question that I pose to you is Article 75, part of Chapter 6, and I dare say that it is part of Chapter 6. And any submissions to the contrary will be inviting the Honorable Panel and your Honorable Chair to be able to rewrite the Constitution to expunge Article 75 from Chapter 6. And this is why this is so. Looking at Article 193 sub-article 3, which is a proviso to the requirements on disqualification, the Constitution provides, and honorable members of the chair of the panel, that a person is not disqualified under Article 193 sub-article 2 unless all possible appeals or review of relevant sentence or decision has been exhausted. And we submit that the decision that impeachment falls squarely under a decision that is subject to review and or appeal. Our candidate, having demonstrated before the returning officer that he has a pending appeal, there was no need for the returning officer to be able to refuse to clear our candidate. I'll be able to invite my colleague to take the remainder of the time.
Sorry. So what was your conclusion, Wanyanga?
The conclusion is that the returning officer had no right to deny clearance of our candidate to be the nominee of the party to contest the gubernatorial elections for Mombasa County. And that is based on Article 193 of the Constitution.
Thank you. I think we've got a new rule out clear.
Thank you, Chair. I'll take 2 minutes. Quickly 2 minutes. I'll leave the Chair will summarize. My name is
Katisia.
My name is Katisia.
We are recording this process for purposes of the proceedings.
Yes.
So just be very, very clear.
Yes. Thank you, Chair. The reason why this complaint because the nominee for Governor Mombasa was disqualified by the returning officer. 3 reasons were given for the returning officer. Number 1, failure to present an original degree certificate. Number 2, failure to present a certified copy of certificate. And number 3, breach of Article 75 of the Constitution of Kenya. Chair and members, with regards to the 2 disqualifications, number 1 and 2, issues of the documents, you will see in your records, in the documents filed, that there are comments by the returning officer with regards to the submission of the certificates by the interested party.
If I heard Mr. Wanyanga well, he said that will be addressed by the interested party since
There's a
he's
point, Chair,
present.
I'm making. There's a point I'm making, Chair. The point is, since those documents were received and acknowledged by the returning officer, it is our view that the returning officer purely relied on a third reason, that is breach of Article 75.
Also,
That is
number 2 and ground number 1 and 2
Yes.
are no longer in contention, according to you.
No. I'm saying, according to me,
Yes.
the returning officer, if the returning officer wanted to disqualify the candidate based on the documents, those reasons would have been stated when the documents were being received. But clearly, she relied on the issue of Article 75, which Mr. Wanyaga has submitted on, and she and members. If you look at the response, she awaited to get advice from the legal team, but by the time she was finishing up with the interested party, she had not received any response from the legal team. So the question I want to ask this committee is, how then did the returning officer rely on Article 75?
Article 75.
Is she mandated by any law when she's doing clearance to take into consideration matters of law, matters before the court? That is the question, Chair, I want to ask.
So
and last, yes.
In short, if I want to summarize what you've said,
yes,
the RO took an irrelevant consideration in arriving at a decision to reject the interested party.
That is the
that
point,
okay?
Chair. That is the point.
RO took
Because she was never advised by any
irrelevant
officer. Then lastly, Chair.
Consideration. The irrelevant consideration being matters before court.
Yes.
That's the irrelevant consideration. That these matters, she ought to have relied on them because they were in another forum.
Yes.
Which ought to deal
And
with
she had
them.
not been advised by legal
No, you
officers.
may not know whether she was advised or not. But
It
we'll
is in
stand
our
for it.
response, Chair.
Let's
Thank you, Chair. Lastly, Chair.
Katisia,
Yes.
slowly.
Thank you.
Slowly. Okay. We have jurisdiction to intervene where a returning officer takes into account an irrelevant consideration. Okay?
Much obliged.
I want to identify that irrelevant consideration you are saying the returning officer took in arriving at her decision.
Yes.
Identify it for me so that I write it down.
Thank you,
so
Chair.
that we write it down.
The relevant consideration is a third reason, which is where she quoted and wrote breach of Article 75 of the Constitution of Kenya.
So why is it irrelevant?
Because
we've identified what it is.
Yes.
Now tell me, why is it irrelevant?
Because two reasons. Reason number one, that consideration, the issue of breach of Article 75, is not part of the requirements which are before the RO to clear candidates.
Not part of requirements, not part of checklist, isn't
Yes.
it? Second?
And number two, Chair, and so on this particular case are aware, there are pending matters in other forms in the courts.
Which have not been exhausted.
Which have not been exhausted, which have not been determined, Chair. There are pending matters before the High Court, the three-judge bench, and even in Supreme, which have not been determined.
And all these things were told to the returning officer during clearance?
It appears she was aware. No. They were not. Yes.
Was she aware or not aware? By your submissions that these matters were in those
Chair, let me say yes, stop it at that point, because the interested party will submit in detail about that particular issue. I want to end by submitting Article 38(3) of the Constitution is very clear. And it provides that...
It is very clear.
Yes.
It means it is not? Yeah. Okay.
Clear.
Go ahead. It's your submission. I'm trying to make light with submissions, okay?
Thank you, Chair.
Yes.
The RO ought to have been guided by reasonable restriction. The law prohibits against the rights of an individual being restricted and reasonable.
So you're saying the RO did not exercise restraint as was required of her under Article 38(3).
Yes,
I think I've gotten it.
That is my point, Chair.
Anything else?
And I'll allow my colleague to summarize our submission.
Good,
Thank you,
excellent.
Chair.
You are within time. Well done.
Mr. Katita, you have spoken so well.
Yes.
But may I say something through it?
No, I'll give you the chance. Senior, I'll give you the chance. And I'm glad you have praised it. We need younger lawyers like that who are very clear in their submissions. Well done. Of course, by saying well done does not mean we agree with you. I don't want you later to say, but you told me well done.
Mr. Chair,
this is another brilliant young lawyer, and we have seen the work that you have done in many other places.
Thank you, Mr. Chair. Permission, I'll pray for your indulgence, given the interjections by the bench.
You are taking 30 seconds more. Go ahead, start.
Now, for instance, I'll make a lot of reference to our list and bundle of which is dated the 15th of June 2022. Now, I wish to address this tribunal specifically on the issue of political rights and legitimate expectation. Now, my first submission,
Mr. Chair, very kind. I can see my colleague referring to a list of bundle of three.
I'm also wondering, we don't have it.
I'm wondering where those came from.
We also don't have it. I was also looking at him that way.
I do confirm
Just
served the same on email. My senior candidate.
We served this morning.
served who?
We served Mukele.
Okay, what about us?
We have supplied.
Salome? Just give us a minute. Mr. Mukele, would you like to confirm by email that you got that?
The documents we have have the link for including a video.
No, check your email. Check your email. We agreed on that. Service and everything will not be a hamper to the hearing of these proceedings.
Agreed, but we have not received that document by physical or email. That's the document.
Are you sure you've not received by email?
Sure, Mr. Chair.
Wanyanga, that's 2 minutes we are losing out of time checking about service and everything.
You know, we served. My colleague.
Do you have physical documents given so that we forget about this story?
Yes, we have.
We need to get the service and non-service is not our issue.
Yes.
I don't know whether my colleague has the button. I can see a list.
Your Honor, the law obligates parties to serve the list. Perhaps I could proceed,
Mr. Oginga,
Mr. Chair, yes.
you know, a document that you have given somebody like this, the way I'm giving Commissioner,
Yes, Your Honor.
there can be no argument.
Yes, Your Honor.
As we go on, can you organize for it to be brought before he does, so that we get on with this? This is 3 minutes we are wasted on service and non-service. You should have addressed me on legitimate expectation.
Chair, we have also just forwarded again. He can confirm on email. So you can proceed.
You see, that's what I was saying yesterday. Okay, proceed.
There's nothing on the expectation which Mr.
Ele does not know about.
That's another.
Let's proceed.
Thank you, Mr. Chair.
A point of
Not anything new with expectation.
It would have been good to look at the context.
Oh, it will change. The law has changed on legitimate expectation. Okay, sawa.
I'm prejudiced.
Let's proceed.
Now, my first submission, Mr. Chair, is that Wiper Party has a legitimate expectation and interest as a political party whose role is to compete for political power, to present candidates for different elective positions. Now, for that proposition, I refer the tribunal to the decision, that is decision number 1 in my list, that is the Diana Kethi Kilonzo case.
We know about it.
And specifically paragraph 163.
We know about it and its history.
163, where the court underscored the issue of the legitimate expectation and interest of the political party to field the candidate.
That matter also involved Wiper Party. We are know about it.
Now, secondly, Mr. Chair, I also refer the court to the decision, that is number 2, International Center for Policy and Conflict, where the court affirmed the said principle, and I refer specifically to paragraph 147 of that authority. Now, thirdly, I submit that the people of Mombasa, just like every other inalienable right, and be represented by a leader of choice in exercise of their fundamental rights and freedoms under Article 8 and 81A of the Constitution, which includes the freedom of choice and for choosing among a pool of contestants in an election. Now, in determining the present complaint before the tribunal, I urge the tribunal to interpret and apply the law in tandem with the express provision and spirit of Article 20 of the Constitution, which mandates this tribunal to apply the Bill of Rights, which includes political rights, in a manner that develops it and permits the extensive enjoyment of the same without any limitation. So that tying that to the actions by the returning officer, while exercising that power as an arrow, and 10 of the Constitution, so that she ought to interpret and apply the law in a manner that permits the full enjoyment of all these rights under Article 38 and 81 of the Constitution.
3 more minutes.
Again, Mr. Chair, I submit that any such interpretation that would result to a limitation of Honorable Sonko's, the Wiper parties, and the people of Mombasa's fundamental rights and freedom would be contrary to the Constitution. Again, in terms of limitation of fundamental rights and freedoms, I submit that number 1, the same must be founded in law. Secondly, the same must be reasonable and must not in any way take away that right. And thirdly, and more importantly, derogations from fundamental rights and freedoms are short-term deferment measures of rights and only granted during times of emergency and urgency. So that in this case, there is no urgency or emergency to warrant the denial of this right. Yes, Mr. Chair.
Very nice, big constitutional principles, but can I allow me to summarize them for you as I need to know?
You've
identified
2
expectation is by the party.
Yes.
Compete for political
Power and to present a candidate of its choice. The first legitimate expectation. The second legitimate expectation you raised is that of the people to choose a leader of their choice without restriction.
Yes.
And if I get you, things done in relation to the present case, the returning officer in declining Sonko's candidate has breached those 2 legitimate expectations. Do I get you right?
Yes.
Good. And any obligation from all this must be within with urgency.
Yes.
Is there anything more you wish to add?
Yes, Mr. Chair.
In a minute.
Articles, that is the general article. As I summarize, owing to the time constraint, let me refer to the vote that is authority number 7. Mr. Chair, permit me to read it. That is paragraph 108. That is the decision . The Constitution has placed on the need for integrity in leadership for good governance. It's a similarly weighty premium the same Constitution has placed on the protection and advancement of fundamental freedoms and rights, in this case, political rights. The need to promote fundamental rights and see to the realization of the potential of all human beings will tilt towards ensuring that even a convict must have his day in court, including the very last day. That appears to the spirit of Article 99(3) when it talks of all possibility of appeal being exhausted. And I urge the Tribunal to also consider Article 193(3), which permits and recognizes the fundamental tenet of an appeal and makes it a bar against any such disqualification. I urge tribunal to allow the complaint.
Thank you,
Mr.
Mr.
Chair.
Ogega. Sorry, it's just that we are pressed for time. I would have given you time, but you know, circumstances. We've got
That's
almost
enough.
300.
I appreciate it,
But
Mr.
I
Chair.
think we have understood your case.
That's
okay.
it.
All right.
Thank you.
If we're in another forum, I will ask for a clap for you. But we can't do that here. Okay? We'll give him the last opportunity. So we'll just go in orderly fashion. So let's hear the IBC and then, sorry, is the interested party supporting the wipers, the political party's position?
Yes.
Then let us, that's correct. Let us hear.
That's why I wanted to chip in.
Now there's a time for you to get in, not only chip in. Okay, so let us hear the interested party so that IEBC gets the chance to respond to all of them. Is that okay, Mr. Mukele? Good. 20 minutes?
Yes.
Okay, we'll try to minimize the interventions on our side.
Yes.
Nyamu, between you and Dr. Kaminwa and Nyakundi, how do you propose to share your time? We will try as much as possible to not to interject.
So let me now address the agreement. And I'm sure you may give us some
Okay. Nyamu?
Yes, hello, Your Honor, we support this complaint. And in support of the same, we will not file any response. We shall address the tribunal in terms of law. Your Honor, first, Your Honor, the basis upon which this claim is based is Article 20 and 38 of the Constitution, where political rights of the interested party are Your Honor, under Article 20, to the great and consistent with the nature of the right of fundamental freedoms. And the word to underline is the greatest extent. So that now any with a question where the rights, the fundamental rights of a person are involved, ought to ensure that it holds him the greatest the rights of the under Article 38 are fundamental rights, which Article 20 applies. The principle underlying Article 20 applies.
So in short, Nyamu,
yes.
Enjoyment of the right should be the norm and derogation should be the exception. Do I
Yes,
get you right?
and actually, the principle that we are actually emphasizing on, principle to be adopted when dealing with the question of enjoyment of fundamental rights of a person. So the principle ought to be that that such officer ought to ensure that it applies the greatest extent. It may also need to go out of its way to ensure that these rights are availed and are not contravened. Your Honor, we are dealing with a case where the returning officer rejected the interested party's nomination papers on two salient grounds. And although I've heard my learned friend say that every issue is confined to Article 75, Your Honor, on the paper, on the document by which the returning officer rejected the interested party's nomination papers, they indicated that they rejected on the basis that they did not produce the original certificate, degree certificate. Your Honor, on the question of that original degree certificate, we wish to submit that in the first that issue, the original degree certificate was not part of the checklists provided. And we invite this tribunal when it retires to look at the checklist of the documents that were required. That degree certificate was 2, Your Honor, the certificate, a certified copy of that certificate was at the inception, and that will be found in our supplementary list of documents. In our supplementary list of our argument is that to that extent, the returning officer actually contravened and ignored the Constitution. Your Honor, question of the fact that the question of why and how, why in this championing and seeking to complain against the action of the returning officer, the Wiper Democratic Party presented these candidates for nomination as provided under the Elections Act within the timelines prescribed. And Your Honor, upon presentation of the same, the name of the interested party forwarded. The name and the interested party was actually given a schedule and invited to present his nomination paper. That's how. allow candidates to regularize any documents that may not have been regular, as long as the documents are there. And indeed, he had the document. And you'll see when you come to our presentation, you'll find that he did all that he could, including even producing the original certificate and a certified copy from Kenyan. Your Honor, the other question now I wish to move to is a question of application of Article 75.
5 minutes so that you can donate some time to Dr.
Yes, Your Honor. Application of Article 75, Your Honor. Your Honor, Article 75 of the Constitution is part of Chapter 6 of the Constitution, which is envisaged in Article 193(3) of the Constitution. In that Article 193(3) provides that a person is not disqualified under Clause 2 unless all possible appeal or review of the relevant sentence or decision has been exhausted. And Chapter 6 is applied under Article 193, Clause 2G, where it is provided that one has been found in accordance with any law to have misused or abused a state office or public office, or to have contravened Chapter 6. So in this case, Chapter 6 is what is mentioned in that particular provision, which applies to the interested party by virtue of Article 182 of the Constitution, which provides that for him to be eligible to be elected as county governor, a person must be eligible for election as a member of the county assembly. So basically, Article 182 ought to be read together with Article 193 for purposes of eligibility, and for that matter, he is exempted under Article 193(3) by virtue of the fact that he has a pending appeal. Documents are presented before the CRO, correspondence from the Supreme Court, together with a petition of appeal, wherein IEBC was actually a party.
Okay.
Now, the question that abounds here, when the returning officer...
In 1 minute, Nyamu, if you want your colleagues to address this.
Your Honor, they could even donate some time, because it is important for me. I have prepared since yesterday. It is important for me to be heard. No. My colleagues, yes. In any event, Your Honor, okay. Let us agree on my timelines. If they donate, let the court sit and wait for me to submit. If they complain, then Your Honor, we have utmost respect. I'll sit down.
I know how passionate you are about this law.
I'm passionate and tenacious.
Yes.
As an advocate ought to be, yes, in relation to our clients.
I have no doubt. We're just trying to manage time. Okay? Yes, yeah, okay. Yes. 2 more minutes, let's say.
Yes, Your Honor, so that I don't lose sight.
Yes.
Let me proceed.
Okay.
Your Honor, when presented with the documents, with the correspondence and pleadings at the Supreme Court, wherein IEBC is a party, if the returning officer was in doubt as to whether those documents were from an authentic source, the returning officer had 14 days to investigate, as required of an administrative body under Article 47. The Wens Parry principle is actually in play. He had the duty to investigate. Did he investigate? Did she investigate? No. She just rubbished and rejected without applying her mind to the matter. And for that case, Your Honor, we are saying that in that regard, had she consulted the legal department of IEBC, she would have gotten confirmation that indeed there is a pending appeal to warrant exemption from Article 192, 193(2), which she never did. And Your Honor, we are saying in that regard that additionally, further information was brought on the same day. Further information was brought from the Supreme Court, showing her that indeed there was an appeal, and that was a letter from the registrar of the Supreme Court. Your Honor, what else, Your Honor? So basically what we are saying is that actually the returning officer did not act as a state officer as she ought to have acted, because as she done so, she would have, Your Honor, she would have investigated, interrogated the documents, and found that the insurgents party was qualified. And Your Honor, we are saying that in support of the case by IEBC.
By Wiper.
By Wiper, sorry. By Wiper. That, sorry. That the interested party was duly qualified, and that the CRO was just excitedly bent on disqualifying the interested party out of malice.
So you're saying the returning officer had a predetermined result?
Yes.
That's what you're saying in
a
short?
fixed mind.
Okay, had a fixed
based
mind.
on influenced by a statement that was, a roadside statement that was made by chairman.
How would you know that?
The chairman did not have...
No, how do you know she was influenced by that? You can say she had a
we have a
predetermined
clip,
mind.
we'll show that clip when our time comes.
Okay, all right, good.
That's all.
Okay, thank you. Mr. Nyamu, I hope I've not inordinately rushed you.
You see,
A bit.
you see, Your Honor,
Yes.
actually, and we are going into the other matter.
Yes.
We agreed as advocates since yesterday that I'm in charge of these proceedings. So when I exhaustively address you, is when I will donate time for my learned seniors to beef up.
Mr. Nyakundi.
So that I'm not...
Yes.
Just to beef up, Your Honor.
Yeah.
Otherwise, the primary role is mine.
All right. Mr. Nyakundi, your role is to beef up.
Yes, and
Beef up means you're beefing up something which is already full.
Yes.
So make sure it does not pour.
Let me spice
Yes.
these proceedings with this observation. I think what we are saying from the perspective of my client, the Honorable Sonko, is that our legitimate expectation was that we will go before somebody who will respond.
Let's have some order, kindly. Let's have some order so that Mr. Nyakundi.
Yes. We are saying that we had an expectation that was legitimate, that we will go before somebody who knows something about the name of Judex. You cannot be a judge in your own cause. And the air around the returning officer was stained by statements which had been made and they were public. They cannot be ignored. That made nonsense of the right of our client to be heard. Because you go before somebody who is independent and who is free of bias. If those elements are present, then all those rights are abused. And I said I was going to Gaza. Those principles of law, which are eternal for any student of administrative law. I remember during my time there was a Professor George, we used to call him Professor George Rukwaro. He's deceased. I think listening to these young men that I have heard, we used to say that if you are not taught by Rukwaro, then you had no administrative.
They were taught by J.B. Ojwang.
I take that back. J.B. Ojwang was, when I was a student, he was then a tutorial fellow.
Oh, okay.
But the point is this, all these are principles that are living. And if they are violated, even to a small degree, you will sense it.
Okay.
They were violated mightily.
Okay, thank you. Dr. Minwa, I trust everything has been said.
I'll take 2 minutes.
2 minutes. 2 with 1 digit 2, not with a 0 at the end.
Mine, may I say that I'm very much impressed with the experience to appear before you. And I'm hoping that with the media around, I'll get some more people who will give me opportunity to address you in the future.
Thank you.
Two things. The returning officer, in my humble submission, committed a serious error. Like this, have an issue that is not very qualified at all. That is on section 75, subsection 3. And he was not aware of section article 75, article 3. He was not aware of article 193, sub-article 3, which makes it quite clear that when proceedings are still pending, then one does not have to suffer prejudice at all. In this particular case, proceedings are pending before superior court, and our partner appeared before the superior court. And it's my humble submission to the chairman,
Yes.
without taking much of your time, that on this score alone, considering that the returning officer is not an expert in the law, he committed a grave error in not communicating or permitting the government to be participate in the forthcoming election. One final word that I would like to say to the committee. Let us not forget that it's the right of every Kenyan to participate. That is really what we stand for. Democracy, the 2010 Constitution. And that is what people fought for. They shed blood for, that they will be able to elect their own leaders. I may go further. There are some people here who may probably criticize me and say to the family of talking rubbish. It does not matter what they are. The last word is in the electorate. It is the people.
Let the people decide.
Yes. Precisely. Oh, that's what they have said.
Thank you. Thank you. We have all learned
Bus.
and may God
Give me a
Well, Chair, yes, and I just like to mention before my learned friend, Mr. Mukele, addresses you, that we have regularized the position, and the documents are before court. I have served Mr. Onyanga, I have served Mr. Nyamu, and I have served Mr. Mukele for IEBC. So they're now properly on record.
Okay, thank you. So that we address that administrative issues, Mr. Onyanga, how long do you need to respond to that application? Because it's an application, you have a right to respond to it. Given the strict timelines that we have, don't tell us 2 weeks because it's not possible.
Are we allowed to do a common response?
It is you, it's your choice, it's your application.
Yes.
To think about it.
Your will not be opposing.
Honorable Chair, we could conduct response.
Gentlemen, Mr. Nyam. Yes, Mr. Wanyanga, you and your team for Wiper, how long do you need to?
Just so that as I consider this, I understand the important organization
In society. Did the ESCC make any representations before the returning officer?
That's the question.
No.
Sorry.
You also have a right. We have a right. Did the ESCC make any representations before the returning officer?
Not directly to the Mombasa.
Not at all. Okay. Did the returning officer make her decision based on any representation made by EACC.
Well, what I can confirm,
No, no,
Chair,
yes,
is that there
no.
is that report 241 candidates.
Was it
of whom
provided to the returning officer?
It was to IEBC and tested.
Okay.
That is first
All
question.
right. I just want you to have that
Yes.
in mind when you're addressing us.
I will try and restrict myself to just that issue.
Remember, as I have sung here right from the word go, all that this committee does is to supervise the returning officer or the decision committee. Whether the returning officer did something right, to take factor into consideration. We must see what was for if any material or representation was not before the returning officer, or based on material provided to them, then we look at that particular representation in a different light. I'm not prejudging your application.
I understand
I just
perfectly.
want you to look at those parameters. So, Mr. Wanyanga, you'll reply orally. Mr. Nyamu?
Will reply orally.
Reply orally. Okay. IBC, I take that you're on the same side.
No, we are not on the same side.
But you'll not oppose.
However, we are not opposing.
You will not oppose. So the opposition will only come from Mr. Wanyanga and Mr. Nyamu. So in order to do things in an orderly manner, I propose that IEBC does their response, okay? And then we do a consideration of Mr. Kagusha's application and see, depending on the outcome, on whether we make representations either. Correct? We finish first with IEBC, who is the party on record,
Yes.
okay? Then we hear his application for joinder or not. Depending on the outcome of that application for joinder, we will then determine on whether he will make any representations on the complaint or otherwise. Is that correct?
Very well.
Dr. Kamino, is that okay?
It's fair.
Mheshimiwa Manzo?
That's
Is that the correct way to
That's-
go?
Yes, that's
Okay, good. All right, Mr. Mukele?
Yes, Mr. Chair. Members of the
Unfortunately, Salome, where is the IBC response? No.
But may I say,
there to be,
May I say
there
something?
there to be.
I'm hoping that my able-learned friend will bear in mind that according to law, strictly this is not the amount. Law. Strictly this matter is not real.
Officer's decision. So it's actually them that we are complaining. We know what we are talking about. The reply by this is the only thing that we have said. Sorry, we're just doing a little.
between the Honorable Mike Sonko, the IEBC, and preliminary objection on that issue. So, Mr. Chair, then this court can then not address itself to that issue before, because it is before the IEBC. I would want to address is premised upon the submission by my colleagues with regard to legitimate. And that will flow into other issues that I'm going to submit. Okay? Now, Mr. Chair, very briefly, legitimate expectation must be anchored in law. It must be anchored in law. And in any event, Mr. Chair, it cannot be relied on in favor of one party, in this case, Honorable Mike Sonko, and in disregard or in ignorance of the other gubernatorial candidates who then presented their documents before the IEBC for clearance, and who were cleared, or not cleared for that matter. Mr. Chair, I've had very lengthy submissions with respect to the style and manner in which documents were presented before the CRO. Nobody is addressing this tribunal on the timelines within which this presentation is supposed to be done. So, Mr. Chair, there's all these submissions on whether a degree was presented or not, whether X document was presented or not, but none of them is addressing the timeline. Mr. Chair, in our replying affidavit, which is before you, it was sworn yesterday, Mr. Chair, we have addressed a very crucial issue, that the clearing of candidates on the 7th, it should be the 7th of June, Mr. Chair, which was the last day for clearing gubernatorial candidates, was to happen or to be effected between 8 a.m. on the 7th of June and 4 p.m. on the same date. Mr. Chair, we have annexed the Gazette notice that was issued and published with regard to those timelines. You will have an opportunity to consider that. Mr. Chair, it is our submission that once it clocks 4 p.m., then the CRO does not have the jurisdiction or the power to receive those documents.
What if the candidate is still in the queue?
Sorry?
What if the candidate is still in the queue?
In the queue?
Is already at the registration center?
If they're in the queue, it's fine. They can receive. That is okay, Mr. Chair. That is okay, Mr. Chair. However, Mr. Chair, as I will seek to demonstrate, by 4 p.m. Understood. By 4 p.m., the documents which were, some of the documents had been presented and received, but there were documents which were critical, which had not been presented to the returning officer.
Let's not have those interventions.
It's okay, Mr. Chair.
Yeah, let's not have those interventions. Council has an equal right as wiper and as the candidate to present his case as best as he can. So let's not have those interventions.
Now, Mr. Chair, my argument was that after 4 p.m., the RO does not have the jurisdiction to receive documents. Does not have the jurisdiction to receive documents. What were the documents, Mr. Chair, that were the subject of the controversy that is before you today? Number one, Mr. Chair, the evidence that the Honorable Mike Sonko
had a degree certificate, the original degree certificate, and a certified copy of the same. Mr. Chair, the provisions of Section 22 of the Elections Act are very clear on this issue. Mr. Chair, the question then is whether these documents had been presented to the returning officer. We submit, Mr. Chair, that these documents had not been presented, and even if any documents were presented, they were not sufficient to satisfy the requirement of Section 22. Mr. Chair, to our replying affidavit, we have annexed a copy, and I mean, we have to be candid on what happened that day. We have annexed a copy of a letter from a law firm by the name Kirui, Kamwibua and Company Advocates. That is our annexure number, the second last page, Mr. Chair. A letter from the firm of Kirui, Kamwibua and Company Advocates. Mr. Chair, what does this letter tell the returning officer, the constitutional returning officer? That Honorable Mike Sonko has not exhausted his appeal and is currently in the Supreme Court. This is a letter from a law firm. Mr. Chair, this letter is received on the 7th of June. It is time-stamped and is received at 4:31 p.m. Okay? Now, Mr. Chair, the question is whether this letter in itself is sufficient to satisfy the CRO that there was an appeal pending. We submit that the letter was indeed acknowledged. It was received. We're not denying that. But it was not sufficient to meet the threshold, Mr. Chair, that is required in law. But, Mr. Chair, it then goes further. You will notice from the complaint before you that on the 8th of June, the following day, 8th of June, a document is presented from the registrar of the Supreme Court, Mr. Chair. The 8th of June, trying to meet the threshold. Which document essentially says, Mr. Chair, that there's an appeal pending before the Supreme Court. This document, I repeat, is presented on the 8th of June.
Had the registrar asked, had the CRO asked for it?
For the letter?
Yes. For the
CRO, on the 7th of June, the CRO had requested for documents demonstrating that there was an appeal pending.
Mm-hmm. So was it brought pursuant to a request or a direction by the CRO or not? Please don't.
No. It was brought, Mr. Chair, on the basis that the candidate had been informed that he was unable to satisfy as to the requirement for degree certificate.
So was that letter brought with the permission?
No, it wasn't. And there's no evidence that it was. Okay. The document was received. I must say that, but it was not brought with the permission of the CRO.
The question that then would arise: why was it being received when it was outside time? Why was it being received?
Mr. Chair, we are public. We are commissioned under the Constitution. If a letter is delivered to the IEBC, are we supposed to turn the individual away and say, go away with your letter?
We've done almost 50 appeals in the last 4 years, in the last 4 days, okay? And yes, we have seen where CROs and ROs are telling candidates you're outside time, I'm not even looking at your paper.
Yes, Mr. Chair. Mr. Chair, that position is different from what we have, and that's why the tribunal has to determine it. Because we are saying a document is brought on the following day without the permission. And Mr. Chair, please tie this with the submission I'm making, that after 4 p.m.,
okay,
unless the candidate is in the queue, okay, the CRO has no jurisdiction. Okay. Mr. Chair, I'm sure you're familiar with the Ferdinand Waititu case. 28 days of filing your petition for, right? Mr. Chair, and again, we are familiar with the unique nature of election petitions and the requirement for timelines. That is why, Mr. Chair, you're seated here telling us you only have 10 minutes because the constitutional timelines have been triggered and they're moving. Mr. Chair, the document could be brought a week later, Are we supposed to turn these
Okay,
individuals?
your submission is some were brought within time, some were brought at outside time, so that their submission about all this documentation, nobody is looking at timelines. And you're putting your context of all these things using the timelines that are there by Gazette.
Yes, as my issue number 2, Mr. Chair. Mr. Chair, in the same vein, you will notice from the proceedings that in addition to the evidence with regard to the appeal, even the documents demonstrating that Mr. Mike Sonko has met, and I think I may already have said this, the conditions of Section 22.
Not met.
Yes, Mr. Chair. And, Mr. Chair, the evidence you will see in the documents file will demonstrate that. It is there for our submission, Mr. Chair, that those documents were presented out of time. We had no jurisdiction to receive those documents. Mr. Chair, I will go to the second issue.
How long will you need on the second issue? Because you only have 5 minutes.
Mr. Chair, because questions have been asked by, yes, I've answered them. So we'll be looking for about 10 to 15 minutes. Because Article 75 has been submitted on for about half an hour.
By who?
Mr. Chair, between Mr. Nyamu and my colleagues.
Mr. Mukele, we agreed to conduct these proceedings.
Agreed.
These are very emotive proceedings.
Yes, Mr.
I want to give time. At the same time, there are people here who are supposed to have been heard at 11.
I hear you, Mr. Chair.
The party wiper has an equal right, just like the MCA from Lonyangalani.
Yes, Mr.
So
Chair.
let us do that with that in mind.
Yes, Mr.
We will
Chair.
give you another 7 minutes.
Okay, Mr. Chair, let me try and condense my argument within that timeline. Mr. Chair, the second reason why the Honorable Mike Sonko was documents were not rejected was very specific, because he did not meet the threshold of Article 75. And Mr. Chair, that is key to these proceedings, Mr. Chair. Mr. Chair, the reason was that the Honorable Mike Sonko had been impeached and did therefore not meet the threshold of Article 75. Mr. Chair, it is my very humble submission that a proper reason, justification was provided by the RO on the ground of Article 75. This, Mr. Chair.
Okay. I want to throw you
Yes, Mr. Chair.
Same question I asked my colleagues here. Is an impeachment a decision within the context of Article 75?
Is an impeachment a decision within
the context of Article 75?
Thank you.
Please, Daktari. Daktari.
I'll take care of
Yes,
Mr. Chair.
Please manage him.
Please manage him.
Manage him. This is the tribunal just wanting to know. I'm not advancing anybody's case. Please don't cheer, don't do anything.
Yes,
If a
Mr.
decision is impeachment, a decision within the context of Article 75.
We know it's not a conviction, or
Yes.
maybe
A conviction.
Yes.
because I'm saying maybe I'm not saying it's not.
Yes.
Is an impeachment a decision within the context of Article 75?
Yeah. First of all, Mr. Chair, I don't.
Yes.
Article 75, sub-Article 3. A person who has been dismissed or otherwise removed from office for a contravention of the provision specified in Clause 2. Mr. Chair, that is what it says. Dismissal or otherwise removed. An impeachment falls within the framework of otherwise removed. That is our submission. But even then, Mr. Chair, in interpreting the Constitution in accordance with the provisions of Article 259, they are very clear, I need not repeat, as to how that interpretation is to be done. Mr. Chair, I want to take you, I would urge that we look at Article 75 vis-a-vis the provisions of Article 193. Both sub-Article 1 and sub-Article 2, Mr. Chair. Mr. Chair, under Article 193, sub-Article 1, and Mr. Chair, I will read it very briefly. Unless disqualified under Clause 2, a person is eligible for election as a member of a county assembly if the person, and then it enumerates those. Mr. Chair, A is registered as a voter. And B, Mr. Chair, satisfies any educational, moral, and ethical requirements prescribed by this Constitution.
Just as a matter of curiosity,
What is the standard of moral
what is the standard of moral in that particular article of the Constitution?
Mr. Chair, you read my mind. I will take
educational is known.
Yes.
You either have a degree or you don't.
Yes.
You either finished nursery school and you got a degree certificate.
Yes.
That's also right.
Yes, Mr. Chair.
But what is the measure of moral?
Mr. Chair, the answer to that, I've asked myself that question 1,000 times. The answer to that is in Section 13 of the Leadership and Integrity Act.
Please read it out.
Mr. Chair, moral and ethical requirements is the title. For the purposes of Article 99(1)(b) and 193(1)(b) of the Constitution, a person shall observe and maintain the following ethical and moral requirements. Mr. Chair, demonstrate honesty in the conduct of public affairs. B, not to engage in activities that amount to abuse of office. C, accurately and honestly represent information to the public. And Mr. Chair, it goes up to H. There's an entire list.
Okay.
And the question is whether the Honorable Mike Mbuvi-Sonko then falls within that. That is the issue the CRO had to deal with, Mr. Chair. So, Mr. Chair, Article 193 is on qualifications and cannot be read together with Article 193.2. You read Article 193.1 on its own. And the CRO found himself in a situation where she had to make the finding that this particular aspiring candidate did not meet 193 as read with, Mr. Chair, Article 75. Mr. Chair, I'll even take you further. My colleagues have harped quite a bit on Article 10 of the Constitution, the common national values and principles of governance. Mr. Chair, and I'll refer you to Article 10C. Good governance, integrity, transparency, and accountability.
So in short, the returning officer took all these considerations and said the candidate did not meet them, and therefore she made a decision based on that article. Isn't it?
Yes, Mr. Chair.
Is there anything else to add?
Yes, Mr. Chair, I will take you to Article 259 on interpretation. This constitution shall be interpreted in a manner that contributes to good governance. Mr. Chair, that is what the CRO took into consideration. But finally, Mr. Chair, on that issue, I will invite the court to look at the Speaker of the Senate with regard, even if you were to find the submissions on Article 193.2.3 valid. This is very important. Mr. Chair, the grounds upon the charges that were placed before the Senate are contained, it is a document that you have.
We'll read it. We'll read it, don't read it.
Mr. Chair, 1, gross violation of the Constitution. 2, abuse of office. 3, gross misconduct and crimes under national law. Mr. Chair, the aspect of crimes under national law is critical. Mr. Chair, under the provisions of Article 181 of the Constitution, Mr. Chair, this sets out the grounds upon which a governor can be removed. Mr. Chair, it includes
My Lord,
where the governor
your time is being wasted.
Dr. Kamino, I'm in charge of these proceedings. Thank you very much.
Where a governor has committed a crime under national or international law.
Okay.
Mr. Chair, the question we want to ask ourselves, because I see a question coming from your side, is under 193.
Your Honor, we may not have an opportunity
please,
to even
please,
respond,
please,
Your
please,
Honor.
please.
No,
please,
this is important.
Mukele,
This is crucial.
Mukele,
You are
Mukele,
privileged.
Mukele.
The time is over.
No.
You can see what's going on.
Doctor, yeah. I don't want these proceedings to degenerate. Mr. Mukele, give me your concluding statement. Statement.
Mr. Chair, I don't know why my colleagues my concluding statement is, and I will refer you back to Article 193 2G. Mr. Chair, 193 2G covers a finding on whether a finding in accordance with any law is found to have misused or abused a state office or public office or to contravene Chapter 6.
Okay, good.
Mr. Chair.
Mr. Mukele.
Yes. Mr. Chair, I'm concluding.
No, listen. I want to record this. That you submit that the returning officer took all considerations in law in rejecting Sonko's
Yes.
registration
Yes.
for candidature. Is that your concluding statement?
And she had to interpret this document.
And she did interpret the law according to you?
Yes.
Good. Thank you very much.
So can I wind up, Mr. Chair, my last statement? It is very
by the Senate, the Speaker of the Senate, the crime against under national law is not included as a crime under Article 193 2G.
Okay.
Therefore, it then takes the Honorable Sonko into the ambit of Article 70, so that it doesn't need you to appeal when the offense is not the one that is specified under 193 2G.
You will look at the publication by the
All
Senate
right.
and you will
Okay.
see that.
Okay, thank you, Mr. Mukele.
My
Thank
concluding
you.
remarks
Yes.
is that the CRO acted in accordance with the law.
Okay.
And that we urge this committee
to uphold the decision.
So fine.
Yes. Thank you, Mukele.
Any questions, Mr. Chair?
No, we'll get to the questions. I mean, it's just but you have a question. Anyway, who was the applicant? Wiper. So only Wiper has a right of reply, 5 minutes. Okay? Just 5 minutes. Okay? And I can see you've nominated one of my heroes, Mr. Oginga. In 2017, we did many cases together.
Yes.
Yeah.
Yeah, if I may proceed, Mr. Chair. Now, on the question of time, I invite the tribunal to consider sections 56 to 59 of the General Interpretations Act on the computation of time.
Article?
That is sections 56 to 59, which talks about computation of time.
This under the Elections Act?
No, that is the General
Interpretation and Cap 2.
Yes, on interpretation of time. So that I also urge the tribunal to take judicial notice of the fact that state and public offices, working hours are between 8 to 5 o'clock. So that a state office cannot purport to limit this time through its own endeavors and use it as a basis to limit any such fundamental right or freedom. Now again, still on the issues of law, I refer the tribunal to the parole evidence rule, which is to the effect that you cannot introduce oral evidence to contradict written assertions. So that when this tribunal retires, it will look at Regulation 43, sub-clause 4, which governs the conduct of a returning officer. That where a returning officer decides that a nomination paper is invalid, the returning officer shall record the decision and the reasons therefore on the nomination paper, add his or her signature thereto, and return the invalid nomination paper to the candidate or its presenter. So that if you look at the complaint, the nomination paper, and the reasons cited by the RO, nowhere in the paper does the RO say that the papers were presented out of time. Or that was the reason that she declined the paper submitted. Same bread, I urge the tribunal again to consider Section 120 of the Evidence Act on the doctrine of estoppel. Estoppel by conduct and representation. So that the RO received the documents, cited the specific reasons she deemed were relevant, and used it as a basis in her view. Again, more interestingly, when this tribunal retires, the tribunal will consider paragraphs 13 and 15 of the RO's affidavit. Now, for the first time, the RO introduces the Senate report. it was not presented at the is trying to decision itself. Article 75 does not even go further to 193.3 as suggested by Mr. Mukele. Nor is it indicated in the document. The only reason cited is breach of Article 75.
Or
it is in the public domain.
Is it a matter that we can take judicial notice of?
It is a factual issue, Your Honor, but when it comes to taking judicial notice, then it means the court ought to also take judicial notice of the existence of an appeal, so that you can not only take selectively only that bit which only favors the commission, as was done by the arrow. Again, Your Honor, the decision of the arrow must be self-speaking. If you read the comments by the arrow, that should be the only conclusion. We cannot now go on a frolic. We cannot now go on a frolic or a hunting expedition to assume that the arrow considered certain other issues that are not indicated in the form. Again, I refer the tribunal to Article 47(2) of the Constitution, which says that every person has the right to be given written reasons of any such decision affecting such persons.
Okay.
So that I submit any decision reached as done by the arrow in breach of Article 47 is a nullity and cannot pass the constitutional test.
Okay.
Again, on interpretation, as I conclude, Mr. Chair, you've been told to treat Article 75 of the Constitution as a lonely, isolated provision of the Constitution. I submit that is in conjunction with the entire Constitution. So that, again, an interesting principle in constitutional enactment, so that there is a presumption that when framers of the Constitution enact earlier provisions, when they come to the subsequent provisions, they are aware of the earlier enactment. So that at no point can a subsequent enactment be contrary to any earlier provision as enacted in the said document.
Is that what you said for basic structure? But that's a story for another day.
No, that wasn't.
There's another forum.
Yeah, that's for another forum. To make
yes. Thank you, Your Honor. Now,
in 1 minute.
Now, while still at that point, that is why Article 193.3 under subclause 2G mentions Chapter 6 of the Constitution. So that again, you ask yourself, where is Article 75 in our Constitution?
Okay.
Is it outside or inside? Now, to conclude, I submit the principle of interpretation includes harmonization, so that the principle of harmony is to the effect that the Constitution is to be interpreted as an integrated whole, with each provision complementing
the other
and supplementing each other.
Thank you very much,
I ask
Mr.
the tribunal to allow the
Thank you.
Thank you, Mr. Chair.
Yeah. Now, as we proceeded here, I want to give my commissioners an opportunity. Kagushi, I'm aware about your application. I want to give an opportunity to my commissioners to ask you a few questions. They are definitely not from the legal background, although she just qualified recently, but she had another background before qualifying. So please answer her exactly as she asks you without going into a lot of legalese. Okay? Give them an opportunity, listen to them carefully, and let them hear what you have to say. After we finish that Q&A session, we will consider Kagusha's application and the replies, and we'll give a decision on it. Okay? The floor is yours.
Okay.
Yeah.
Thank you, Mr. Chairman. Ladies and gentlemen, I could hear this the whole day. All the parties have presented their their arguments with so much passion and intellect. And I find myself completely unable to even say, is that right or that's wrong, because those were responded to beautifully. I think the materials that I have to enable me to make a decision on this particular case has been executed beautifully. Secondly, I'd like to thank Ms. Lumala for expressing a vote of confidence on this bench. Maybe next time you need to come with a lot more women than you have done. I want to thank you for the arguments that I have. It has completely satisfied my curiosity on how this case will be settled. Thank you.
Thank you. Thank you, Commissioner. Madam Commissioner, I'm sure you have a few questions before you make your statement. Yes, go ahead.
Good afternoon. Yes, mine is just to thank you and to let everyone know that we are not, this is a quasi-judicial committee. So we are not subject to strict rules of evidence or criminal law. But we are in between, below proof of beyond reasonable doubt and above balance of probability. So, meaning that should anyone is not satisfied, the other avenues. Thank you.
Okay. I will add on to what the two commissioners have said. We didn't find ourselves here by mistake. It is Parliament that said a committee will hear this. So we exercise a supervisory role of our arrows. We live in this country. We watch news just like everybody. So when we see public statements saying that you have no confidence in the committee, you will put in preliminary objections against the committee, and yet you are here before us, we wonder whether there is a different wiper out there, and the good wiper, the good lawyers we have seen here, the good Sonko outside there, and the quiet Sonko we are seeing here. You know what we are saying? These institutions were made by Parliament for you. When a big political party like yours and a big candidate like yours, when you express confidence in this institution, you foster democracy and you encourage others to come. But when you make public statements out there, the chairman of the commission may have said something, but the chairman is not seated here.
Yeah.
This gentleman were passed by Parliament, this gentleman and the lady were passed by Parliament to come and sit here because of the experience they have had and the independence that they have. So the public statements that you make out there and our mandate, it is your duty, if we are to foster democracy in this country, to approach the institutions that Parliament has given you and your representative have given you for dispute resolution. So we are all glad that we were prepared for something else, that more what not to say. But we are jurisdiction of our returning officer. What the returning officer did, we are going to examine it in light of the law and the facts that you have done, and we believe we'll give the best decision that will not only be good for the candidate, for the party, other than interested parties, but for the Republic. Okay? Good. On that account, can I give 5 minutes to Mr. Kagushia to say what he has to say? I hear 5 minutes. So in 15 minutes, we should be done. We will come back at 3 o'clock to get our ruling on his application. If we allow it, we will give you a time when he can make his representations. If we don't allow it, we will give you a date when we will give the decision based on the case between the parties. Are we together? Is that acceptable? Good. Mr. Kagushia.
Thank you, Your Honor.
Pole for these people shifting the ground under you.
It is okay. It is in the nature of our work.
Okay, here we go.
And as officers of forums such as this.
Okay.
Your Honor, I think the question before
Okay, let's restore order again. Let's restore order.
The question before is whether EACC should be here, and the submission on behalf of EACC is that the Ethics and Anti-Corruption Commission has always been there. The reason it has always been there is because of the mandate conferred upon it by the Constitution, specifically Article 79, which says that Parliament shall enact legislation to establish EACC, and EACC shall do two things. One is enforce Chapter 6 of the Constitution, and two, ensure compliance. In addition to that, under Article 80, Parliament shall enact legislation for the effective administration of this chapter, that is Chapter 6. So we've always been there. Now, in the discharge of EACC's mandate, one of the things EACC has done is investigate the interested party. It has made recommendations regarding the integrity status of the interested party, and those recommendations were transmitted to IEBC in the form of an advisory. And that was on the 31st of May. So that by the time decisions about whether or not to accept the candidacy were being made.
Council, please. When you do that, we get distracted from, yeah, go ahead.
Thank you, Chair. By the time decisions were being made about whether or not to accept or reject the candidacy of aspirants, EACC had already discharged its mandate. And I would like to commend the fact that the Assisting Council has mentioned a number of petitions which are consolidated, where EACC is a party in the majority of those petitions. My learned friends were with me in that court. I will not bring those matters here, but one of the natural consequences of that process is that if a candidate is bad, he has an avenue to air his grievance. And we are in agreement that this is the right forum. So if EACC was a part of the decision that led to this DRC, then EACC ought to be a party in these proceedings.
Okay.
In addition to that, Chair, we are parties in other matters before you. Just this morning, we appeared on record in complaint number 239 of 2022. So we're already here.
Were you made a party or you applied to be a party?
In this particular one, we applied, but in the other one, yes, we were a party.
You were a party?
Yes.
So you had the right of audience by right?
Yes.
Okay.
That is my point. So we've been here. It's not a question of whether we are supposed to be here. As I summarize, because I'm trying to be as surgical as possible, even the rules for this DRC say that any person aggrieved can join these proceedings. Now,
are you
let me clarify. I am aware that EACC is not. Yes.
Are you aggrieved by the returning officer rejecting Sonko's registration application?
That is not my submission. My submission is that I would like this DRC to extend that spirit of inviting any person to come before this DRC and make such presentations as are relevant. Now, my point is whatever EACC has done in the discharge of his mandate is central to what is happening today. And that is why we need to be here.
Thank you.
And I'm surprised my colleagues are challenging because we've been together with them along the same journey. And all I would like to say is this. It's not a question of winning or losing. It's a question of having this constitution interpreted in a way that is purposive and for the benefit of all Kenyans. So whatever happens, whether we succeed or we lose, justice prevails.
Thank you. Sanyamunga, you're not delegating to a younger lawyer.
No, I was hoping my colleague Mukele will go first before you.
Mukele said he's not opposing the application.
We are not opposing.
They're not opposing the application.
Surprisingly. Oh, fine.
That's not necessary.
Honorable Chair, in response to this application, we oppose the application. The Ethics and Anti-Corruption Commission has no identifiable stake in the proceedings before you. And that these proceedings are not akin to proceedings brought under Article 23 and Article 258 of the Constitution.
Article 20?
Article 23 and Article 258 of the Constitution. Honorable Chair, the decision that we are challenging before you is a decision by the returning officer, not by the Ethics and Anti-Corruption. And no such order, in our complaint we have not sought orders against Ethics and Anti-Corruption Commission to warrant them to be participating in this dispute. No material has been presented before you, either in response by the RO that they had submissions or they considered a report by Ethics and Anti-Corruption Commission in arriving at the impugned decision we are seeking to impeach before you. Honorable Chair, in sum, Independent Electoral and Boundary Commission and it does its duties and exercises its mandate independently, such that if the Ethics and Anti-Corruption were to submit a report as alluded to by my colleague, the independent IEBC is not a conveyor belt that they will receive and adopt it as it is. It is incumbent upon the IEBC to safeguard its independence.
Okay, 1 more minute.
Against interference or otherwise issues brought to it from external forces. We urge you to Honorable Chair, Article 249, Sub-Article 2B speaks to the independence of the Commission, and that the Commission is independence is not subject to direction or control by any person or authority.
Thank you very much, Mr. Nyamunga.
We urge you to disallow this application, and once our candidate will be cleared, then they can be able to lodge a complaint against us.
Thank you. I'm glad you've used the word when.
Yes.
May I say something?
Before you do, now between you and Mr. Nyamu, can you agree between yourselves who will say something?
He can speak and also can give me a little time to say something.
Okay. Out of deference. Okay.
May I say something?
You want to say now or after Nyamu? I suppose no. Let Senior say something, and then you substantively respond.
Your Honor, to some extent, I'm happy that my friend from here has raised this point for you. There's been this type of loose talk in the media. There is a principle of law, international law, called precautionary principle. Yeah, which applies in this country. I have argued, I have invoked a number of cases, and that's been accepted in the constitutional courts, where you have to minimize the risk. Even assuming that there is such validity in law, the ESC, the anti-corruption agency, can give reports, and those reports can be acted upon. It's my humble submission, we would be destroying our democracy completely. We would have no democracy in this country at all.
All right.
Any allegation can be made, or anybody can go to ESC or to the agency and make a complaint, and a person will be disqualified. Principle.
Thank you.
May I say with some little bit of humility, I introduced it in my submission.
Thank you.
Thank you.
Thank you. Thank you, Dr.
Principle.
Thank you.
I reject what he is saying to you.
No, Dr. Kaminwa, this gentleman is doing a job. And you never know, it may be under very difficult circumstances, but he's got to do that job. Okay? Just like you also did in the 80s. A job has to be done, and he's doing it well.
Well, I'm under duty to expound on the law.
Thank you.
And on the Constitution.
Thank you. Thank you, Dr.
The way Chief Justice Marshall of the United States said long time ago.
Thurgood Marshall.
Yes, honorable members. We oppose the application for joinder as filed by EACC in these proceedings. One of the reasons is that EACC is not mentioned anywhere in the decision by the CRO. The decision is annexed to our documents, Your Honor, and it is actually at the top on the left, and there is no mention of EACC. What is mentioned is breach of Article 75 by virtue of impeachment, as has been said by my learned friend when he submitted. Now we've looked at the checklists at ESCC, and there's no requirement for ESCC involvement.
But there's a form, isn't there a form?
But there's a form,
a declaration
there's
form.
a declaration form. Firstly, I wish to submit that in the checklist, there's no involvement of ESCC that is required in the checklist of documents that ought to be presented before the CRO to warrant the CRO's consideration of any ESCC's role. 2, even where, of course, there's a form, Your Honor, which was submitted. That particular form was received at ESCC in March 2022. And Your Honor, there's no mention in the affidavit, in the supporting affidavit, that this particular form is not authentic. So, Your Honor, these proceedings are not proceedings about what is out there. They are proceedings on the conduct of the CRO, Your Honor. And if anybody was free to appear before this tribunal, if they felt like, without having participated at the CRO's proceedings, then we'll be here until cows come home.
Thank you.
Your Honor, your ESCC matters that have been annexed to that particular affidavit, and actually we wish to show that no prejudice will be suffered by ESCC. The ESCC annexures that are there, Your Honor, one of the annexures that is very fundamental is the charge sheets.
Okay, good. We will look at that.
Your Honor, let me say something about the charge sheets, Your Honor.
Mr. Nyamu?
I don't know what I'm doing wrong that I'm being cut short.
No, you're not being cut short. I think I've given you sufficient time.
May I finish, Your Honor?
I've given you sufficient time.
May I just mention the article that I'm...
Please do.
Your Honor, I don't understand. I don't understand, Your Honor, because I'm only submitting.
It is time.
I'm a client that I'm representing.
It is time. Nyamu.
Yes. So, Your Honor,
don't get worked up.
I'm not getting worked up, Your Honor. I'm only wondering. Your Honor, there's a charge sheet here, Your Honor. That charge sheet presupposes proceedings before court that are not been terminated.
Okay.
And based on presumption of innocence as prescribed under Article 50, Your Honor, this particular issue, Your Honor, cannot be brought to this tribunal. And again, it would only out of malice that they would invite these matters to this tribunal when it's actually before another forum.
Let me ask you a question, Mr. Nyamu.
Yes, Your Honor.
I hope you've relaxed now.
I'm relaxed, Your Honor. I'm only wondering why, when I'm making my point and before I finish, I'm being stopped.
No. Mr. Nyamu, did IEBC do a list to the returning officers? And if it did, list of aspirants to returning officers?
Yes.
It did. Was Sonko's name there?
It was there.
It was
actually,
there. Okay.
He had been gazetted. There's a gazette notice.
Thank you.
Yes,
now, I want to turn to you. You can now sit. If you did an advisory to IEBC, why did IEBC send Sonko's name to the returning officer?
Your Honor, perhaps because my learned friend Mukele is here, he may explain that. But as far as our mandate is concerned.
Yes, but you did an advisory.
That is correct.
Telling IEBC we have this
220,
this number of people have issues.
Yes.
Okay?
Yes.
IEBC looked at that report, isn't it? That would have been the best time for IEBC to intervene. To the extent that IEBC had your document and they still took the name to the returning officer, why do you want to come in these proceedings now?
Allow me to clarify by saying at the beginning, before my learned friend Mukele submitted, he actually pointed out something that is very accurate. That he does not oppose my involvement here, but we are not together. Okay? And the reason he would say that is because IEBC is under pressure to comply with the recommendations, the advisory of EACC as the independent fact finder in terms of investigation and establishing the integrity status of candidates. IEBC disagrees because just like EACC is independent, IEBC has an argument that it is also independent. Just thrash out this issue of whether what EACC does is of any consequence whatsoever in this country.
That is in another forum, isn't it?
Yes.
We're just asking what we're wondering ourselves. You want to be enjoying it now. Yet, you yourselves did an advisory.
That's what we wanted to get from you. Also, sorry.
Okay, all right. I'll give Commissioner a chance to ask a question in relation to the application and yourself, and then we retire. For the other parties who are here, we really regret where this has taken quite a lot of time, but whatever time we leave here, we will hear all the matters that we have confirmed. Commissioner, in regard to the application for joining.
Absolutely. In terms of the application, I will not ask this question, but I say with clarity that your role is advisory. Whether we take it or not is something that is subject to us as a commission.
Yes, I just wanted.
No, please. Let her finish. Let's, in an orderly manner. Yeah, I'll take your question. Yes.
Yes, I just also wanted to say that we also work with other agencies in various areas. If you see, even with the police, we work with them to provide security. So we are also, apart from being independent, we are also interdependent.
Okay. Lastly,
yes,
Mr. Busha, there's the general advisory that you do to the commission, isn't it?
That is correct.
And then that is now to the national returning or to the commission as a commission.
Yes.
But candidates are cleared by their respective returning officers, isn't it?
Yes.
So that senators are cleared by the CROs, governors by CROs, president by national returning officer, MCAs by constituency returning officers. That is the person who actually clears the candidate. That's the decision. That's why it's called a returning officer. And his word is final, okay, subject to this committee, isn't it? Not even the chair can overturn the decision of a returning officer. This committee, under law, under Section 4, can do so. Why doesn't, I'm not talking about this specific case, why doesn't EACC present what they have individually against each person, against that returning officer, so that that returning officer can take that decision based on what the EACC has done, and which would give EACC a right to come to the committee? Why doesn't that occur?
Allow me to start by saying that even in this current, we will be coming in to say that we are in agreement with what the CRO did. Okay? That is what, if we are granted leave to join these proceedings, that is what we will be coming in to say, that we are in agreement with what the CRO did. But in terms of advising the IEBC, the moment communication from EACC, from the CEO EACC to the CEO IEBC, the understanding is that it has been transmitted to the institution in its entirety.
But to a returning officer, the returning officer takes what's in front of him or her.
Yes.
Was this material provided to the returning officer?
As far as I understand, the moment we transmitted the information with the 241, that information was communicated to
When
the
we got the advisory, and when of the candidates went, so that we are sure.
I'm in full agreement because I think the deadline was 7th of June and we transmitted on 31st of May. I'm not sure about the date we received the 21,000, but there was barely a week in between.
Okay, we thank you all very much. For council, I think Commissioner did give our gratitude to your submissions and the industry that has come in. If we have not given you a lot of time, it's because of the pressure of work that we have.
No issue. I was only giving my client and giving the laypersons, they needed to know that an Article 50 is something of innocence.
Thank you.
Of course, you may have assumed that Chairman is not there.
Yes.
Your Honor.
They don't like being called laypersons. They are very...
As we finish.
Lay in law.
Lay in law, yes. Lay in law. Yes, Your Honor. I apologize. Your Honor, as we move to the next matter, I believe that our matter is next. And we have, that is 127 now, in that order. It relates to the same matter.
Okay.
And we have
One thing, just one thing. Communal reminded me, thank you, Commissioner, and congratulations, Commissioner.
Yes. Okay, I'm the only one left out, but that's okay. I'm not fishing for compliment. No.
Thank you, Chair.
Okay, so what we will do, we will not hear 127 today. We will hear 127 tomorrow so that we give you enough time. We want to give these guys whom we have already confirmed their matters also a chance. They are also as important as Sonko and Wiper are. Okay? And remember, we already done. So what we will do, we will retire now, we will come to give a ruling at 2:45 on the issue of joinder. Okay? And then at 3 o'clock, we will hear all these other matters. Yesterday we were here until 9 o'clock. Please let us also allow to give justice to the smaller people, but who also have got an equal right in the Constitution, like Microsoft. All right? So let's come at 2:45. We'll give your ruling, and then thereafter, we'll give you an update for the decision for this one, and 127. And Salome, is there anything we can do? Fix at 11. And give it adequate time. Because if we have 127 now, these people who we are confirmed for, I think. So come tomorrow, we will fix very few matters tomorrow so that we give you adequate time for 127, but have given you a date for we have served justice to these other people. Is that okay? Nyamu?
Honor, it's only that we had actually allocated ourselves.
Yes, but we didn't realize this amount of time would be required when we were confirming these others. Let's just give them
that affects something tomorrow, Your Honor.
No, it will not affect anything. Or afternoon tomorrow, which one is that?
Your Honor, it would have been in the evening. Your Honor, are you sitting in the evening?
We are taking this until 9 o'clock.
Then could we check 5:30
tomorrow?
Yes, 5:30 tomorrow.
Your Honor, that might be a bit tricky for some of us. We have a pride.
Okay. Let's deal with all
I
this.
think 11 a.m.
No. Tomorrow at 11 to 1:27. For now, come at 2:45 the application for joinder, and then we'll give you a date for decision for this one. Everybody else, please come back at exactly 3. We will give you time, not as much as Sonko's, but we will give you time. You have a right.
One small correction, Your Honor, with respect.
Yes. 11.
Yes. I've associated myself with Governor Sonko recently.
Yes.
And one thing that I've been impressed about his character is a lover of small people. To such an extent that he himself is a small man.
You know, it's really impressive. It's really impressive. Like Simon said in the Bible, your servant can now depart in peace.
Nobody wants.
KTN, no?
Tena pressure sana na bola. Hawezi kumbuka sana. Nakumbuka. Hadi za
Imeenda vizuri. Sasa unaona, sasa I believe unaona bro, kishakulia hivyo